you co-own a property with your spouse, what happens when you pass away? It's one of two things, and it depends on how you have the title set up. So you can have the title set up either as tenants in common, which is typically default, or you can set up as joint tenants with rights of survivorship. Typically, you have to have this requested. And so what's going to happen is with tenants in common, you do not avoid the probate process. And so when you co-own that 50-50 with another individual and you pass away, your half of that house will have to go through the probate process to pass down to them. And so if you have a will, you can name them in the will to take over the full ownership of the property. If you do not have a will, that property, your half of it, will be split up per the intestate laws. As an example, in Georgia, your spouse and your kids will evenly split the assets in your estate, and then your spouse will get a minimum of 1/3. So your half of the house will get split up and your spouse will only get a portion of it. With joint tenants with rights of survivorship, it will avoid the probate process and go directly to your surviving co-owner, which is going to be your spouse. So joint tenants with rights of survivorship will avoid the probate process. Tenants in common will not avoid the probate process. If you want help changing tenants in common to joint tenants with rights of survivorship, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.